wasting money on cures. Forgot how to fix myself. They say that time is free. Then why is it so precious? Oh, I'll save memories in my head, like Polaroids on walls. They remind you to look ahead. Time is running out. Time is running out. Lately I've lost my track. I've sailed the deeper seas, hoping to find something to bring back better times. Oh, I'll save memories in my head, like Polaroids on walls. They remind you to look ahead. But time is running out. 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 Time is running. Time is running out. Time is running out. What if my best days aren't over? They can't be over. They can't be over now. Time is running out. What if my best days aren't over? They can't be over now. Time is running out. Time is running out. Time is running out.
Good evening, everybody. It's John here from Tutor to You, welcoming you along to another exam clinic for A-level law. Tonight we're concentrating obviously on the AQA board, and we are thinking about paper 3 and contract law. And I'm joined tonight by Liz on the left hand side of the screen and Gemma in the middle. Good evening to you both.
Hi.
Now, if first of all, I hope paper 2 went well for you. I appreciate that that's one that's been done and dusted now, and so we're going to move on to paper 3. And I'm aware of the fact, of course, that paper 3 isn't until next week. But let's have a think about what kind of questions we need to be thinking about right now as we're getting our preparation together. So the idea of tonight is to field as many questions as we can over the next 25 minutes or so from yourself on the contract law side of paper 3. We've got a little slide that we're going to start off with just to get ourselves thinking about what the paper actually involves. But as soon as you like, do pop your questions into the chat window, and we'll try and start to answer them as soon as we've got enough to actually get going with those things. So I see one or two of them already coming in. So shall we have a look at this first slide, guys, and then we'll get on to the questions in a moment.
Fab. Yes. So the first slide which we're showing here is just as a little bit of a reminder. So do you need to answer all questions on the paper? Now, having sat 2 papers thus far, you should know that the answer to this is yes. But we just wanted to take this opportunity to just kind of give you a few reminders about kind of the timings and what topics. So as you all know by now, you've got your shorter questions. which are worth 25 marks at the start of your answer. So you've got your 5 multiple choice questions, a 5 mark explain, a 5 mark apply, and your 10 mark apply. Okay, so it's really important to remember that question 6 will be on a non-substantive topic. So that will be your delegated legislation, your European Union, the judiciary. What's really nice about paper 3, and I realise that many people probably won't think there are that many nice things about contract law, is that there's quite a bit of repetition across the papers of these non-substantive topics. So, you know, nature of law is a non-substantive topic, but you should already revise that content for paper 1 and 2. The aspects of the judiciary and aspects of access to justice and funding, also you should have revised for previous papers. So that's actually reducing the amount that you need to revise. It's really, really important, particularly if you're aiming for those higher grades, that you are revising all of those non-substantive topics. You've also got the concepts of law topics. So moving into the longer questions, question 9 could be on a concept or theory. So morality came up last year, so I think it's really unlikely to come up again. So really important that you've got your 10 marks for, you know, justice, balancing conflicting interests and theory. And then you've got your application questions with contract law. Now, there are less contract law substantive topics. Hopefully you've noticed from, you know, the notes that you've created, that actually there is less information that you have to learn for contract. Actually, you could really break down the substantive topics into 4 areas. So you've got formation, vitiating factors, terms, and discharge. You've also got remedies, but remedies, you know, you'll be asked in every question. What this means is that, you know, something in each of those topics is most likely going to be in the exam. So you need to make sure that you have revised all of the topics in real detail. Okay, Gemma, is there anything else that you want to add to that explanation before we move on to the questions?
Yeah, you're right there, Liz, in saying that some of the ELS topics you will have already studied and revised for. And that's the same in concepts as well. Like you said, we've got law and justice and law and morality, which you will have already learnt from papers 1 and papers 2. The only new one that won't have been covered in your revision is balancing conflicting interests. So do spend some time looking at that and thinking of how that relates to contract law, which it does really well. That is, you know, you can see that in contract law in lots of different areas, in the Consumer Rights Act 2015, balancing the interests of the trader and the consumers, trying in remedies as well. We can see that. So that does fit really well in this topic. So make sure you are revising that as you go through and thinking about how that would relate to the different substantive areas that Liz has just mentioned there. But hopefully you are feeling more confident now, having already sat 2 papers and you know, got those under your belt, so to speak, and ready to really finish off with this one with the confidence that you should have grown in revising those topics already and the lesser substantive areas there. Liz also did mention about remedies, and it's really important that you are giving a fully rounded answer. So finishing off saying, you know, well, what remedies are available, because ultimately, you know, that is what the individual in the scenario, in a client in a real world situation would want to know. What are the remedies? What can I get here? I've been affected, and you know, what does that mean for me in terms of what can I get back? So make sure that you do put that in. So yeah, we can take a few questions now. Keep the questions coming in, everybody, please. So Liz, do you want to take the first one?
Yeah, so Ethan has asked, in contract law, do you ever need to discuss causation? So the only context in which you need to discuss causation is if you are specifically asked about damages. So within the law of damages, you've got some kind of, there is a but-for test and there is a remoteness test, and you know, but that level of detail I don't think's been examined before, and I don't think you're really going to be required to go into it. So the answer is no. You don't need causation in the same sense that you do in criminal or contract. There are some causation aspects when you really dig into damages, but I don't think that that level's ever going to be needed, only ever really if you had a 5 marker or just on damages. Okay.
I think we've got a question in from Lucia. How would you know what topic to speak on within a 30-mark question? For example, is it intention or misrepresentation? Well, that is part of where you're gaining your marks from, really, of being able to go through and analyse and pick out those areas. Now, to make sure that you are focusing on the correct area, go through the question, spend those few minutes annotating, looking through the scenario and annotating the different relevant areas. You should be looking for a 30 marker for 3 different areas, 3 indicative content groups that you're being examined on. So maybe intention to create legal relations, there might be misrepresentation, and there might have been something on formation of a contract or consideration there. So do you have to spend that time? You have to be able to seek out those areas in the question. Now, that's a skill that you should be honing now, preparing for the exam. Look back at past exam questions. You don't need to answer the question in its entirety, but you could be going through and marking up old exam questions and annotating them to spot the different areas, because that is a key skill that you need to know. As Liz said, there are lesser areas in paper 3 than in the other papers. So you could be having a little tick box, running through your mind of all the different areas that you've studied. Is this relevant here? Is this relevant here? Etc. But you only need to speak about the areas that are relevant. If intention to create legal relations does not come up in the paper, then you do not need to be discussing that. Okay?
Yeah, I would just add to that out of the 4 substantive areas, so I always use the acronym with my students. Frogs very frequently drink tea. I don't know how we came up with that, but that's irrelevant. So frogs very frequently, formation, vitiating factors, and I get them to draw a line in between that. So FVF, formation, vitiating factors, are pre-agreement issues. So if your scenario has got lots of, Liz said to Gemma, would you like to buy my pen? Gemma said to Liz, no, I wouldn't. If there's lots of stages of negotiation, then it's indicating to you that it's something pre-agreement you've got to discuss, an aspect of the formation. Or if there's a lie within the stages of negotiation, or there's a falsehood in there, that's a pre-performance issue. So the F and the VF is the frogs very frequently. The drink tea is the discharge and the terms. So if you look at the scenario and it's telling you, and it's not going to explicitly say there was a contract formed, but if your scenario begins with saying Gemma and Liz had agreed for Gemma to buy Liz's car, that's the scenario telling you there is an agreement. The agreement's not in dispute. If the facts of the scenario then explain how the performance is not complete and exact, you know that you're going to be discussing some aspect of discharge and terms. So I get my students to write that, the FVFDT with a line in the middle across the top of the scenario for question 10 and question 11, just so they can really focus their mind. This is a harder paper, very much so, because in criminal, if the victim's died, that you're within the realms of homicide. If it's to do with property, it's theft and robbery. The scenario specifically lends itself to very distinguishable areas, whereas in this exam, your scenario is going to be about the creation or the execution of a contract. The scenarios are all about contract law, so it's really, really easy to get in there, read it and think, I don't know, it could be everything. So think about, okay, is this to do with creation? Is it a pre-agreement issue, or is it a performance issue? And then that's going to narrow down the areas of discussion. If there is, a lie or pressure during the negotiations, it's a vitiating factor. If it's talking about, the different stages of negotiation and what was offered in the context, it's a formation issue. If it's talking about, non-complete performance, is it, breach, or, the different aspects of partial performance? Is it frustration, or is it a trader and consumer situation? Okay, so I also say to them, and Ribena, add on the end, because they are for remedies. That's how we remember it. But yeah, it's really hard just sometimes to work out exactly what bit of contract law it is that you've got to go through, and it's just a process of elimination. It's really, really important to take the time on this paper much more than the others, to annotate that scenario, determine what it is you're going to be discussing, and then starting to mark your answer. I say to my students, spend 40 minutes on each of the 30 markers. Okay, the rest is a mark a minute. If you spend 10 minutes reading, annotating, rereading the scenario, then that is absolutely not time wasted. Okay.
Yeah, absolutely on that. I mean, it's key that you are making sure that you are dealing with the correct areas. You can look out for things, like intention to create legal relations. Is it a scenario does it say between two friends or between a brother and sister, which might be leading you down the route to say, oh, well, is it talking about intention to create legal relations? But do spend that time and, make sure that you are picking out those different areas to your advantage, really, because this is one where it's not as easily spotted as you can in papers 1 and 2. Okay, so I think we've got a question here from Kate. Best tips for doing an offer and acceptance question. Now, you might have seen some past exam questions where it's Liz made an offer to Gemma to sell a car for £200. Gemma said she'd think about it. Then John comes in and offers to buy it for £250. So Liz comes back and offers £300. And we've got this scenario with all these different offers, and somebody's accepted. We might have the postal rule in there, and it can be quite a difficult scenario to even pick apart. So in that scenario, if you do have that comes up in the exam, the best thing to do is I tell my students to do like a little timeline down the side, again annotating the question, making sure you've got things in the correct order so that you can deal with it appropriately. Now, offer and acceptance is a huge area. So firstly, you've got to determine, was an offer made? Was it an offer, or was it an invitation to treat? You might have studied cases such as Fisher and Bell or Partridge and Crittenden. There's different things as, how long does an offer last? Is it revoked? If there's a counter offer in there. So I think in that scenario, I said John came in and offered a different price. So Liz came back and offered more. That would extinguish the original offer. So you've got to make sure you've got the timeline running throughout the scenario as you're going through there. And as I've just peppered in there, various different cases to support everything that you are saying as well. Okay. When it comes to acceptance, again, there can be various different ways that a contract can be accepted, and sometimes it might be in the scenario that somebody's accepted it by prescribed acceptance, or it might have been through the postal rule, or it might have been through some other electronic means of communication. So making sure that you are making sure that you've got the scenario facts correctly so that you can apply the law. And those questions can be quite confusing, so look at that, make sure you've got all that in your mind, and then apply the law to that, backing up all your points made with case law to give a fully rounded answer there. Remember how the postal rule also does apply if that becomes applicable in your question. Okay.
Okay, we'll move on. There is a question from Angel who asks, how do you identify the consideration issue? So I'm presuming what you mean is how do you identify if it is a consideration issue that you've got to discuss? So what is unique about contract law, which is different to paper 1 and 2, which makes it a challenge, is that if in question 10 and 11 on, paper 2, you've got negligence. You're running through the whole of negligence. You're doing duty, breach, and damage. If vicarious liability comes up, you're working all the way through it. In contract, it's different. So with formation, if there are formation issues in a 30-mark question, you do not automatically go through all of offer and acceptance, consideration, or intention to create legal relations. So the mark schemes from AQA always indicate that they just want you to discuss areas that are in dispute. What you are looking for, and just to kind of follow on from what Gemma said, what you are looking for are areas that are contentious. So areas, something that's not legally satisfied, that requires discussion of a legal principle to resolve. So if it was a scenario, which was detailing the stages of negotiation, but there was clear agreement at the end of it, you might talk about consideration if the consideration was passed, or if there was a real discrepancy in the value of the consideration, and talk about Thomas and Thomas. You might talk about intention to create legal relations if it appears that it is an area for discussion. So if, for example, it's a social situation, but actually they've made it really formal, so that's going to indicate to you that you've got the presumption that there's no intention in a social situation, but then you're going to rebut it. So it's really, really important to kind of, and it's subtle, and you've got to really carefully look at the scenario, but in order to identify what legal principles have you got to draw upon to resolve any issues which are not clearly satisfied within that scenario. Okay, there's another question. Yeah.
I think we've got another question there. Rex, what's the difference between rescission and restitution as remedies? Liz mentioned remedies before. You have got to make sure you're looking at your various different remedies. For example, in misrepresentation, your different remedies are available there for whether it's been fraudulent, negligence, or innocent. So rescission is essentially cancelling the contract. It's set aside, and both parties are restored to the position before the contract was entered into. That can be used in fraudulent or negligent misrepresentation. Restitution, the claimant there is restored to the position they were in before the contract was made. They might be repaid any monies that they originally paid out, for example, and that could be a possible remedy used in economic duress. You have got to make sure that you are including those and the difference between equitable remedies, or whether there has been damages payable, liquidated damages or unliquidated damages, and the different heads of damages that are applicable there. If there might be a loss of a bargain or a loss of opportunity, perhaps if somebody's been left out and not able to enter into the chance of obtaining a benefit, winning a competition or some opportunity that they had available there. There's also repudiation, and remember all your remedies that there are under the different legislation as well. Consumer Rights Act is a key piece of legislation that you need to be looking at in contract law, and looking at the specific remedies and the sections as well, which allow for say if there has not been if there's not been performance of a contract within a reasonable time frame.
Okay, so we've got another question from Kazmi, which says, what's the difference between frustration and economic duress? So they are two very different things, and in fact sit within different substantive areas. So frustration is a form of discharge of contract. Discharge of contract refers to how does a contract end. So if there is a frustrating event, it's a supervening event, an event that kind of intervenes between agreement and complete performance, which prevents complete performance. The nature of it is characterised by that it is not the fault of either party. It is an unforeseeable, unanticipated event which renders future performance of the contract significantly different to what was anticipated. So a frustrating event, which is a fault of neither parties, there's a 3-part test which you have to fulfil, and upon the occurrence of a frustrating event, the contract is discharged. It is ended at that point. And frustration is unique because you don't have damages, but you do have remedies which are ordered under the Frustrated Contract Act 1943. And that will often be a really big topic of conversation in a frustration question. I was looking at a past question today. And it was a frustration scenario, and it said, one party had paid over this and one party had done this work before the frustrating event, and you're going to have to unpick that in the remedies and work out how the courts would resolve that. Economic duress is a vitiating factor, and a vitiating factor is a pre-contractual issue that renders a contract voidable. So economic duress is when illegitimate financial pressure is placed on one party by the other party to enter into the contract, and it then renders it voidable. So they are completely different areas and have a different effect on the contract and different remedies in court.
Yeah, your two vitiating factors there are, your misrepresentation and your economic duress, which make a contract voidable, aren't they? But frustration and economic duress are completely separate areas there. Okay. We've got any other questions?
Yeah, so we've got one there from Tyron, which says about specific performance.
Yeah, so when we're talking about performance should be hopefully complete and exact. Hopefully that's how every contract would end. That's the ideal, isn't it? Of course. But sometimes that cannot occur, as Liz said. If we've had something which has frustrated the contract, it might have been impossible or commercially sterilised, for example. Sometimes in remedies they might be applicable, might be for specific performance of a contract. That can only ever occur in certain instances, however. If it's a particular item that somebody wants, but it's not always applicable to do that. It's only when the goods are perhaps so unique that no other remedy would do. Thinking of cases such as Besic and Besic, for example. Again, you only have to bring up specific performance of a contract if it is relevant to that question, and that's a real key area here, picking out, not necessarily going through all the different remedies that are available, but picking out which remedies are available here specifically for this scenario and which ones would be most appropriate to the scenario facts as presented. So if it is a very unique item in the scenario, then perhaps specific performance may be appropriate if that is still an option in the contract.
Okay, we'll take the last question then, which is from Ethan. So Ethan said, for question 9, is it morality, justice, balancing conflicting interests? You were partly right. The answer is the specification says morality, justice, and balancing conflicting interests. It's my belief that AQA have said that because just when a concept comes up in one paper, it won't come up again in another paper. So it's my understanding that justice can't come up in paper 3 because it came up in paper 1. So I have advised my students to revise morality, balancing conflicting interests. Really important not to forget the theory. They have previously had question 9 on all on theory, all on freedom of contract quite a long time ago. So it really could be theory. So I've advised my students that it can't be justice because that came up on paper 1. It's unlikely to be morality because it came up last year. So really to focus efforts on balancing conflicting interests and theory. And then that brings us to a close, I think.
Thank you very much. Yes, I'm just having a look in case there were any other quick questions coming in. We have reached the end. This is our final live stream for AQA A-Level Law this academic year for obvious reasons. So on behalf of Liz, on behalf of Gemma, on behalf of myself and everybody at TutorTU, we do wish you all the very best of luck with your exam next Tuesday. Big thank you to those people who have contributed some good questions tonight, and of course a very, very big thank you to Liz and Gemma for their responses. As I say, the very best of luck and hope to see you again at some point in the future. Goodbye, everybody.